Welcome back to the weekend, okay? Well, this week, the Supreme Court could finally rule on Donald Trump's far-reaching claim of presidential immunity, or they could not. That's the beauty of the Supreme Court. You know, Donald Trump is basically asking the court for a get-out-of-jail-free card for his full-throttle attempt to overturn a presidential election. By taking their precious time on this case, the justices have actually halted Donald Trump's federal election interference trial. That means that a verdict is less likely before November's election. Beyond justice delayed, this case could also reshape the presidency. Axios explains, quote, the next week may redefine the limits of presidential power for generations to come. Andrew Weissman and Melissa Murray are kicking off another hour back with us. I would just like to ask how is this even a thing, Melissa? I mean, if anyone listened to the oral arguments, Donald Trump asked his lawyers are asking the justices to say, you know, they gave examples of you could shoot someone, assassinate someone, a president could order an assassination, and that should be covered because he needs immunity. That's a crime.
No, so, first of all, that's exactly right. Some of the arguments that were made at that oral argument on April 25th were specious to the point of being stupid. And the court can discharge those. They can dispatch with those very quickly. The court doesn't have to reach every issue. It doesn't have to answer every hypothetical. It can answer what's squarely before it, like this particular case, and it can write a very narrow decision. But we know from that April 25th oral argument that Neil Gorsuch said that they were going to write an opinion for the ages. And apparently that takes ages because we have been waiting a long time for that. And it could be that the Chief Justice is insisting on some show of unanimity, and that's why it's taking a long time. I think it's more likely that there are a ton of dissents here from the three liberal justices and also a lot of concurrences as we're seeing as this term plays out that even among the conservatives, there isn't consensus on how to decide some of these basic issues like the Second Amendment, for example. So we may get an outcome where there is a unanimous judgment, but lots of different decisions or separate opinions, and that takes a long time. But the underlying point is, if the question is if Donald Trump has been immunized in this criminal trial, that's already happened because this court has taken so long to decide this question.
Andrew, I agree with Simone. It's really frustrating in so many levels to see the court really putting the country in this position on this question, which seemingly to everyone is easy to acknowledge the speciousness of it, as well as the real problems that could be set upon the country if they decide the wrong way. And former Attorney General Eric Holder had this to say on MSNBC's Deadline White House. Just take a listen to how he is assessing this moment.
A president can violate the American criminal law if he or she is doing something in their official capacity. That is an absurd and dangerous conclusion. And I'm worried, given the length of time that it has taken for the Supreme Court to decide this case, that something along those lines might come out of the Supreme Court.
And it is that something along those lines that have a lot of court watchers and folks like ourselves here concerned about how this court comes down on this. Do you think they're going to try to take a little bit from column A and column B on this, give a little bit of immunity to Trump, or send it back and say, you guys, the lower courts, take a closer look at this aspect of it? How do you assess the concerns that people have in terms of what the court may do next?
Well, I think the big picture to sort of underscore something that Melissa ended on is that the choices here are something that has already happened that is horrendous to something that the court could do that is unimaginable. In other words, there's no good news. The fact that they took the case, the fact that they could have decided this 6 months ago when Jack Smith asked the court to hear it, and now they are giving this former president de facto immunity, that has happened already. What Attorney General Eric Holder talked about was the unimaginable, which is that the court issues a decision that gives the presidency some form of criminal immunity. I don't think that they are going to go that far. but it is certainly possible. And they may carve out a small area where they do think that's true, where the president has exclusive powers. But I don't think they're going to say that he can, for instance, order SEAL Team 6 to kill a political adversary, to use an example that came up in the Court of Appeals.
You know, as a matter of fact, we also have the sound of Justice Sotomayor using that exact hypothetical.
Exactly.
Take a listen.
If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
They could, and why? Because he's doing it for personal reasons.
Okay, so that should be absolutely chilling. Your former boss there, Melissa, it's hard for me listening to that to imagine, as other people suggest, that she is out there trying to work out some type of compromise on this. But you tell me.
I don't think it's necessarily a question of compromise. I mean, that was a pretty stark hypothetical. But I do think that the Chief Justice, on a decision like this one, he'll want to present a united front for the court. We saw this in Trump versus Anderson, the Colorado disqualification case, where they were nominally unanimous, but then there was all of these roiling separate opinions that made clear that there were real divisions among the justice, even as there was this veneer of unanimity. I think that's likely what's happening right now. They're trying to get to some point, some very narrow point upon which they can all agree, but there are a lot of other decisions. And we know that this court can move quickly when it wants to. At the end of Trump's term in 2020, they cleared the shadow docket of a bunch of executions, knowing that the Biden administration was coming in and putting a moratorium on the federal death penalty. So when it suits them, and often when it suits conservative interests, they move with a quickness. But here, this is taking longer, and we can speculate as to why.
So is that how it works then? Could it be that the dissents or the concurring opinions are not actually even written yet? I'm just thinking about the Dobbs leak, right? Mm-hmm. And there was a fully drafted text. Yeah. And so what are we waiting on? Are we waiting on edits to is it a Google Doc? Break it down for us.
It's not a Google Doc.
How are they doing this thing?
I mean, there would be leaks if there were Google Docs, and we already know they have problems with leaks. But generally what happens is that there is a majority opinion. If the Chief Justice is in the majority, he has the prerogative of assigning that opinion. And I think for a case like this one, he would assign it to himself, but it would be presented as a per curiam opinion, as the writing of the entire court. But it would be circulated among all of the justices. Justices would ask for different modifications or alterations in order to sign on. And in some cases, they would also perhaps say, well, I'm signing on to the judgment, but I want to write a separate concurrence about the reasoning, or I want to write a dissent or whatever. And those have to be circulated as well. And other justices have the opportunity to join those concurrences and dissent. So it is an iterative process. It does take a lot of time. But I want to emphasize, it doesn't have to take this much time. This court in the 1970s, when it was deciding the Watergate case, took 54 days from the start of that case to the end, and 8 days after Richard Nixon resigned.
So you have, Andrew, the interesting sort of narrative that's also playing out there, because there are other cases, as we know, and Judge Tanya Chutkan this week sort of signaled that if the case gets back on her docket, and this is the Jack Smith case, she'll give Trump's legal team at least close to 3 months to prepare. That could still leave runway for the case to get started before the November election, which would, of course, upend Trump's ability to travel in the final weeks of the campaign. So there's still some matters, if you will, in the judicial world of Donald Trump that he needs to be concerned about here. What do you think is that a realistic timeline for the Jack Smith case and any of these other cases out there, that there's still a possibility at least one of them could land and get started before November?
Michael, you missed all the talking that Weissman's eyebrows were doing as you were reading that reporting.
So
that's why I went to Andrew, because I knew his eyebrows would be talking.
So, look, is it theoretically possible? Can you see the sun and the moon and the stars align? Yes, I think that I don't think there's a chance that you're going to see any of these three cases go forward. One of the things that could happen in the D.C. January 6th insurrection case, you sort of alluded to in your, and I think I didn't answer it in your last question, which was, it is possible that the way the Supreme Court rules on this issue of immunity is that they say that there needs to be a pretrial assessment by the district judge of what is official conduct and what is personal conduct. That happened in a civil case that the D.C. Circuit had, where they sent it back for that kind of hearing. And although that wouldn't be a full criminal trial, if there is leeway for Judge Chutkan to have a hearing with witnesses, that's something she does not need to wait 80 days for. She does not need to put that off. She could have a hearing where Jack Smith calls witnesses, and these would be witnesses who the January 6th committee did not have available to them. For instance, the former vice president of the United States. So I think that to me is the one potential prospect where we could see significant additional evidence play out before the election, where you have that kind of hearing before Judge Chutkan.
Oh, why is it taking so long?
I know.
If that's what they're going to do, why won't they just do it?
I know. But, you know, it's the law.